Okay, everyone, we'll be getting started shortly. Thank you very much. If you have not already, please silence your cell phones. All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon, and welcome to the Court of Appeals for our, second, or I don't know, maybe there were more sessions before this morning, I don't know, for this afternoon. Anyway, I'm Chief Judge Donna Stroud. To my right, we have Judge Lucy Inman. To my left, Judge Darren Jackson. And we have one case for argument now, which is State v. Overcash. And so we have the timer automatically set for 5 minutes of rebuttal. If you want something different, just let us know and we can fix that. I'm sorry.
I'd like to reserve 8 minutes.
8 minutes, okay. And of course, we have a loud vehicle going by at the inconvenient moment, so 8 minutes on that. And we do have the windows cracked, for better ventilation. So sometimes we have fire trucks and loud trucks and motorcycles and things go by. So yeah, just, feel free to stop talking and let it go by if you need to. So, all right. Okay, and we're ready to proceed.
Good afternoon. I'm Assistant Appellate Defender Wyatt Orsman, and I represent Mr. Overcash in this case. Before I get started, I'd like to thank Ms. Boyce and this court for agreeing to to reschedule this argument from October. I appreciate it. Thank you. When a jury sees just one frame of a much longer video, when it sees one moment in a longer sequence of events, there's a real danger that the jury will be misled by not seeing the whole recording, that their understanding of the events will be distorted by the lack of context. To guard against this danger, the rule of completeness, the rule explicitly built on fairness, normally allows for the admission of the entire video in order to provide the jury with a complete picture of the events. Interpreting identical rules of evidence, both this court and federal courts have recognized that Rule 106 may also require the exclusion of evidence when the proffered evidence fails to provide a complete picture to the jury and the completion evidence is unavailable to be presented at trial. What fairness requires is determined on a case-by-case basis. For example, in Yevekpour, the federal district court believed that fairness required the exclusion of 3 snippets of a longer video of a border stop that had been erased. The court noted that the snippets had been cherry-picked because they were believed to be beneficial to the prosecution's case, that the government had intentionally deleted the rest of the recording, and that the absence of the complete video prevented the defendant from being able to make an independent determination whether the missing portions had anything of value for the defense.
If I can just interrupt you to ask, I believe you argue in your reply brief that you're not advocating for a per se rule. Is that correct?
That's correct.
Okay. If it's not a per se rule, what are the specific facts in this case that require exclusion? Is the defendant still required to show how lost material is necessary to understand the evidence that came in?
So, as I understand your question, I think there are 2 parts to what you're asking. I think the cases that I discussed in the briefing and including in the memorandum of additional authority, I relied primarily on 3 cases. Yevekpour, Codrington, and Hall. And those 3 cases, if you read them, they espouse 4 different factors that courts should look at in figuring out if fairness requires the exclusion of the evidence. Those 4 factors are whether the completion evidence was intentionally deleted or inadvertently deleted, whether the loss of that evidence deprived the adverse party, here Mr. Overcash, deprived the adverse party of the ability to review the completion evidence in order to determine if it had any value to the defense. The 3rd factor is whether the missing evidence would have been crucial evidence to the proponent's case, here the prosecution's case. And 4th, whether the proponent, here the state, the proponent of the incomplete evidence possessed other evidence that would provide context and thus mitigate the danger of misleading the jury. So those are the 4 factors that I think can be pulled out of Yevekpour, Codrington, and Hall from this court.
And how, doesn't the 2 managers' testimony mitigate by providing some context?
If the testimony is allowed to stay in, it would provide context. But my argument is the testimony about the photographs as well as the video should have been excluded. The testimony about, the testimony from Mr. Overcash's boss, Ms. Sorano, and Ms. Heath, the manager of the convenience store, that was all derivative testimony. they were not eyewitnesses to the passing of the check. They had zero eyewitness. They didn't witness any of the underlying events. They had to watch the inadmissible evidence in order to give their testimony. So I think if the testimony stays in, it does provide context. But I don't believe the testimonies should stay in. I think it had to be excluded as derivative testimony of the photographs. So going back to answer the second part of what I understand your question to be, Judge Inman, is what are the facts of Mr. Overcash's case, right? With those four factors, what are the facts that line up with those factors? And here, one of the, just like in Hall, right, the case that this court decided, unlike in Hall, the surveillance video here is indisputably unavailable, right? The defendant in Hall was the person who wrote the letters that were then introduced at trial, right? And just like in Codrington, the erasure of the video in this case was inadvertent. There's no claim by Mr. Overcash that the state or anyone else intentionally deleted the surveillance video. But we know from Hall, we know from Codrington that doesn't matter. It doesn't have to be intentional destruction. Because in Codrington, it was the same sort of scenario where there was a surveillance video in a department store of the defendant shoplifting some perfume bottles. And the first 10 to 15 seconds of that video were accidentally deleted. The next factor is whether the surveillance video in this case would have been crucial evidence to the state's case against Mr. Overcash if they did possess it, if they did have it. And I think if you look at page 182 in the transcript, where the parties are arguing about whether this evidence should come in, both the photographs themselves, the screenshot, the blow up, and then the testimony, the prosecutor is perfectly candid with the court. He says this is the evidence that links Mr. Overcash to the passing of the check. There's only speculative evidence that he stole his coworker's paycheck. There's only speculative evidence that he forged her signature. I don't think there can be really any serious dispute that if the state possessed the surveillance video, it would have formed a crucial part of its case against Mr. Overcash. I think that's also underscored by how hard the state fought to get the photographs in. And going back to Codrington for just a second, there, the federal district court held that the missing 10 to 15 seconds of video wasn't crucial evidence because they presented the testimony of the detective who watched Miss Codrington shoplift the perfume. And the detective's testimony indicated that the entire video, including the deleted portion, was just one continuous shot of the defendant walking through the department store with the perfume bottles in her hand. So based on that testimony, the trial court decided those 10 to 15 seconds were not crucial. And they showed pretty much the same sort of stuff that was on the rest of the video. Here, like in Yevekpour, the screenshot that Ms. Serrano took, right, Mr. Overcash's boss, the screenshot that she took was cherry-picked, just like the video snippets in Yevekpour. She took that screenshot at the precise moment that she thought the surveillance monitor showed Mr. Overcash approaching the cash register to pass the forged check. So the only evidence saved from the entire video was saved precisely because it was believed to be beneficial to prosecuting Mr. Overcash. I think there's another critical factor here that also weighs in favor of excluding the evidence. In Yavekpor, the prosecution had eyewitnesses to the border stop that formed the basis of the charges, the smuggling charges. And the eyewitnesses were able to give, I mean, they were border agents, and they were able to give eyewitness testimony about that border stop. And in Codrington, the detective was able to testify. Not only able to testify, he was called to testify by the prosecution, and he testified about what he saw. He saw the defendant walk through the department store with a perfume in her hands. But in both cases, the prosecution's eyewitnesses were subject, they were made available to cross-examination by the defense. Their memory and credibility could be tested. They could be discredited. They could be impeached in front of the trier of fact. But unlike in Yavekpor and in Codrington, the state in this case got to have its cake and eat it too. I think it's important to remember that the transaction, the passing of the check, not only was it recorded by the surveillance video, but it was witnessed in person by the cashier who accepted the check. The state knows who that cashier is. Her name is Brittany Dixon. The state elected not to call Miss Dixon, even though she could have testified just like the border agents in Yavekpor and just like the detective in Codrington. She could have given the jury a complete picture of the passing of the check. She could have given the context, right, for the sequence of events that were from the lost video. As a result of the trial court's admission of the evidence in this case, the state was able to introduce unimpeachable photographs and avoid having to call an impeachable witness. The state was able to imply to the jury that Mr. Overcash passed the forged check through the admission of evidence that could not meaningfully be challenged about the underlying events. It sounds silly to say this, but the defense couldn't cross-examine the photographs about what they depicted because they're just photographs. And the only other evidence about the passing of the check was from Mr. Overcash's boss and the manager of the store. But they couldn't be cross-examined about their firsthand knowledge of the passing of the check because they didn't have any.
But that could be established before the jury, that they didn't have any firsthand knowledge of the passing of the check, right?
Yes, if they were.
So that, I mean, that they could be cross-examined about it and established for the jury that they didn't have that firsthand knowledge.
Yes, and that's what Mr. Overcash was forced to do once the photographs were admitted and once the trial court allowed them to testify. But it's Mr. Overcash's position on appeal that the photograph should have been excluded and their testimony should have been excluded because it was derivative of the photographs and the surveillance video that they watched. So, it's my position that once the photographs once the photographs are excluded, there should have been no way for them to have testified about what they saw in the video. By not calling Ms. Dixon to testify and by admitting or introducing the photographs and the testimony, the state was able to insulate its most misleading and therefore prejudicial evidence from meaningful testing by the defense. Under Yavik-Pour, under Codrington, under this under this court's decision in Hall, fairness dictates that the photographs should have been excluded. And as we've discussed a little bit already, the challenged testimony should also have been excluded. In Yavik-Pour, the court excluded the video snippets of the border stop, but said that the border agents, it was perfectly fine for the prosecution to call the border agents as witnesses to testify about what they saw at the stop, because they had eyewitness testimony of the underlying events. That same logic should apply here. Right?
I know the cases talk about how utterly unfair it is to ask the defendant to speculate about what could be in the rest of this missing evidence. And acknowledging the unfairness of that, I have been trying to think, what could that videotape show that would be helpful to Mr. Overcash's defense?
Well, assuming for a moment that we allow
Yes.
that we allow the testimony from the boss, from Mr. Overcash's boss,
Yeah.
Ms. Serrano, the testimony from the manager, Ms.
Yeah.
Heath. They testified that they watched the video, they saw a man that they identified as Mr. Cash walk up to the cash register holding a piece of paper, put a piece of paper down on the on the counter. The cashier took that piece of paper, ran it through a machine, put it in a drawer, and then hand Mr. Overcash some money. That also describes someone turning in a lottery ticket. A man holding a piece of paper, putting it on the counter, giving it to the cashier, and getting money in return. But I want to be perfectly clear. That's complete speculation, right? Virtually anything I say is complete speculation because Mr. Overcash never had the opportunity to see the missing surveillance video, right? I mean, I'm forced to come up with hypotheticals, but that's the kind of thing that would have been helpful to Mr. Overcash, right? Had he been able to see it. He could have made a determination on his own whether the missing evidence had any, right, it's not just exculpatory value, it's any explanatory value. Could he have, right, and there's some helpful language and reasoning in Yavik-Pour. Was there anything in the missing language that he could have used to correct the distortion created by the jury just seeing that one snapshot in time, right? It's not necessarily just evidence that would exculpate him, but would the jury get a more comprehensive picture? Would they understand the context better? And obviously he can't do that because he never saw it. He never had possession of it, right? He's completely hampered from being able to meet the state's requirement that he explain how the picture is out of context and how the rest of the video would provide that context, right? That's an impossible burden for Mr. Overcash to meet. But it's not just Mr. Overcash, right? A criminal defendant in this case. That would apply to defendants or plaintiffs in civil cases, right? malpractice cases, negligence cases, right? It doesn't just impact criminal defendants, right? I mean, that would be an impossible burden for any party to meet.
So what is the difference between a photograph and a video, really, for purposes of this? I mean, a video is a lot of photographs. I mean, it's a lot of frames. And so you've got a photograph, and obviously they may show different things, but I mean, why would they be treated differently?
The court in Yavik-Pour addressed that argument and said that surveillance video, or well, any video for that matter, it's less likely to confuse a jury because there's a continuous stream of information.
But if there was a situation where all we had was a photograph, for whatever reason, somebody took one, or maybe your camera malfunctioned and just took a picture for some reason, but all you had was a picture. It's nobody's fault that all we have is a picture, it's just all we have is a picture.
No, that's true. It's nobody's fault, but in that case, I think you fall back on the language of Rule 106, which is it fair for the adverse party to not have the full context given to the trier of fact?
Well, I mean, that would be the full, the only thing we have in my hypothetical is there's a picture. It shows exactly what our picture shows.
In your hypothetical, is it taken from a surveillance video? I mean, is it one frame from a surveillance video, or
No, it's just
or something else? Yeah, well, I mean, I think then Rule 106 just doesn't even come into play because the picture isn't part of a broader piece of evidence, a bigger piece of evidence that provides more context to the trier
What
of
if the
fact.
person took 10 pictures, but we only have one of them?
I think you would still need to determine on a case-by-case basis whether it would be fair to include them. You know, what happened to the other 9? You know, why don't they have them? Did the adverse party have an opportunity, you know, to assess their value? Right? I mean, it would be, you know, without applying the factors used in Hall and Yavik-Pour and Codrington, I think, you know, it's hard to come up with a off-the-cuff answer. But I mean, I think you would need to apply those factors and see whether, you know, fairness required or, you know, allow them to be admitted or not.
We're into your rebuttal.
I'm into my rebuttal time, so let me just end by saying the trial court should have excluded the photographs and the derivative testimony. That was prejudicial error to not exclude the challenged evidence, and Mr. Overcash should be awarded a new trial. Thank you.
Thank you.
Good afternoon, and may it please the court. My name is Sarah Boyce, and I'm counsel for the state. The trial court allowed the state to introduce a photograph of Mr. Overcash at the Dunn's Gas and Grocery at the time that Carmen Gonzalez's stolen check was cashed. The trial court also allowed one witness to testify about that photograph and 2 witnesses to testify about what they had seen on surveillance video from the convenience store. Mr. Overcash argues that the admission of this evidence violated Rule 106, the rule of completeness. This court should reject that argument and affirm the trial court. In deciding this case, the court has numerous different paths to affirmance, but the following is the most straightforward. First, this court should hold that Rule 106 can never be used to exclude testimony, and thus that the trial court properly allowed 1 witness to testify about the photograph and 2 witnesses to testify about the surveillance video. Second, this court should hold that Mr. Overcash cannot establish prejudice. If the testimony about the video and the photograph is allowed, then Mr. Overcash simply cannot establish a reasonable possibility that the outcome of his jury trial would have been any different. These two holdings would provide this court with the most straightforward path to an affirmance.
Sorry about that.
That's all right.
We're near a fire
I
station.
should have invited my 4-year-old. He would have enjoyed this
Yeah.
with sirens. So again, those two holdings would provide this court with the most straightforward path to an affirmance. Of course, the state also believes that the trial court rightly allowed the introduction of the photograph that Dana Soriano took while she was watching the surveillance footage at the convenience store. Rule 106 does not apply to photographs, nor is it typically used to exclude evidence. Moreover, even if Rule 106 does apply to the photograph, Mr. Overcash's trial counsel failed to explain how the photograph could possibly be misleading to the jury. Again, however, the state respectfully submits that the most straightforward path to an affirmance here is to focus on the witness testimony and the fact that Mr. Overcash has failed to establish prejudice. Because Mr. Overcash cannot establish that the trial court's decision to allow the 3 witnesses to testify was an abuse of its discretion, and because he cannot establish prejudice, the trial court should be affirmed. I'd like to start by focusing on the testimony as Mr. Osborne has done. And before I get to the substance of whether Rule 106 should apply to testimony, I do want to briefly address the proper standard of review for that question. The state's position, of course, as you've seen in the briefing, is that Mr. Overcash's trial counsel failed to object to the introduction of any of this testimony about either what was in the photograph that was taken or the surveillance footage. The best argument that Mr. Osborne has for an objection can be found at page 184 of the trial transcript, where the trial counsel asks a clarifying question of the judge about whether, in fact, the witnesses will be permitted to testify about the video. But at no point in any of the 3 witnesses' testimony does the trial counsel clearly object to testimony that describes the content of the photograph or that describes the content of the surveillance video. Because of that absence of any objection over the course of those 3 testimonies, that is clearly to an explanation of what those witnesses saw, this court should review the admission of the testimony for plain error. There's some conflicting case law, both from this court and the North Carolina Court of Review, as to whether this court even can apply plain error to discretionary decisions from the trial court, or rather, whether in fact those decisions should just be permitted to stand. And I submitted some authority in a memo that supports the idea that for discretionary decisions, there is no plain error review. Similarly, this court has previously said that when plain error is not raised until an advocate's reply brief, that the plain error objection has not been preserved. But setting that to the side and assuming for purposes of this argument that plain error does apply, we think it's clear that the trial court did not plainly err here, and I'll move on to the substance. Rule 106, on its face, applies to writings and recorded statements, and that is not what we're discussing here. Here, Mr. Overcash's objection is to testimony, which does not fall within any reasonable definition of what a writing or a recorded statement means. So on its face, Rule 106 does not apply. The 2 cases that are discussed at length in the briefs, the Codrington case, which again Mr. Osborne has raised here, and the Thorne case that was invoked in the trial court below, are both cases that involve the loss of a video, just like we have here. And in both of those cases, the witnesses were nevertheless permitted to testify about what they had seen in the video. In Codrington, as my friend on the other side has explained, it was a video that showed a woman walking through a department store, and the employee who had watched that lost video was nevertheless permitted to testify about what he had seen in that video. Similarly, in the Thorne case, there was a video of a bank robbery, and the police officer who had watched that lost video was nevertheless permitted to testify about what he had seen in the video. Concededly, those are not Rule 106 cases. The defendants in those cases did not raise Rule 106 objections, but I would submit that's because Rule 106, on its face, does not apply to testimony, and thus there was no viable basis to make such an objection to the admission of testimony just as in this case, there's no viable basis for excluding the testimony on the face of the rule. Mr. Osborne has made an argument that simply because the testimony is derivative of this lost video, that should preclude it. I'm not aware of any case that supports that argument. The various cases that he cited, again, are cases that object to whether or not the lost evidence should come in or a piece of the lost evidence should come in, but they're not about whether testimony about the lost evidence should come in. And again, Codrington and Thorne both suggest that, in fact, testimony about lost evidence can come in.
If you could just take us through, assuming hypothetically that that this panel were to agree with the defendant that the screenshot should have been excluded
Sure.
from evidence. Take us through laying the foundation for the testimony of these two witnesses.
So of course they would need to validate the fact that they had seen the video. Is that what you're referring to?
Yeah, I'm
The
just
trial?
sort of asking how we parse that out. In other words, if the testimony is derivative from an item that is excluded, and I understand your argument that it shouldn't be.
Sure.
But if testimony is derivative from something that's excluded, can counsel lay foundation for that witness's testimony?
Yes, Your Honor, I believe they can simply by asking the witnesses to describe the personal experience that they had of watching the video. It wouldn't be any different than laying a foundation for having watched a particular crime that has already happened, occurred. They would need to just ask questions that confirm, in fact, that the witness does have personal knowledge of the evidence that's in question. So whether or not the evidence is directly before the trial court or not, the witness can nevertheless testify to their personal knowledge of that evidence. And in fact, of course, Rule 1004, which is typically the rule that addresses lost evidence, which is commonly known as the best evidence rule, what that specifically says is that when original evidence is lost, evidence that's essentially derivative of that nevertheless can be used so long as the state did not deliberately destroy the evidence, or there's three other objections there. But essentially the whole purpose of that rule is to address a situation like this one where the original is lost, all that we're left with is derivative evidence, and whether that is the photograph as the best evidence that we have here of the video, or it's testimony describing the lost evidence, that evidence can come in. Of course, as you've said, there needs to be some kind of foundation for the testifying witness's knowledge and personal familiarity with that evidence, but so long as that has been established, the witness is perfectly well suited and well qualified to testify. And of course, there's been no objection here to whether, in fact, Ms. Soriano and Ms. Heath did, in fact, watch the video, and no objection to whether a proper foundation was laid for their familiarity with that. Mr. Osborne has put forward several factors that this court could use in determining whether or not this evidence should have come in. We could, of course, dispute whether or not those factors would be satisfied with respect to the photograph, and I can deal with that briefly. But with respect to the testimony, one of the factors was whether the state was to blame for losing the evidence. Of course, the testimony was never lost. The testimony came in at trial. The trial counsel had the opportunity to cross-examine those witnesses who were offering the testimony. So the four-part test collapses entirely when we focus exclusively on the testimony and whether the testimony was properly introduced at trial. In his briefing, Mr. Osborne drew this derivative rule, or what I'll call the derivative rule, the rule that we should keep out derivative evidence from the Supreme Court's decision in State versus Thompson. And it is true that the Supreme Court in that case discussed whether or not evidence that's clearly related could come in. But of course, in State versus Thompson, the court was still talking about other writings and other recorded statements and whether closely related other writings and recorded statements could come in. Rule 106 has never been used to eliminate evidence that is not a writing or a recorded statement. And again, of course, has never been used to prevent a witness from testifying about lost evidence. Again, setting that aside, even if the court is not persuaded by the argument that Rule 106 should not bar testimony, This court's precedent and the precedent from the North Carolina Supreme Court is clear that it is the defendant's burden to explain why the evidence that the state seeks to introduce would be misleading to the jury and why further context is needed. Here, defendant's trial counsel plainly failed to satisfy that standard. All the trial counsel said was, quote, "That's out of context." There was no explanation as to why it might have been out of context. And if the simple suggestion that it might be taken out of context were sufficient, that would allow parties to exclude enormous amounts of evidence the moment that it was lost, simply by suggesting that perhaps the little evidence that remained might be taken out of context. And Chief Judge Stroud, this gets a little bit to the question that you were raising about photographs. If defendant's argument is taken to its logical conclusion and the police go to a crime scene and take 200 photographs and some portion of those is lost or isn't developed properly or whatever the case might be, a defendant could theoretically come into court and say, I didn't ever get to see these other photographs. There might have been something in those photographs that might have exculpated me, so the state should not get to submit any of this evidence or introduce any of this evidence because I didn't get to see the small portion that was lost. So if Rule 106 is turned on its head and allowed to be used as a rule that excludes evidence any time a defendant can make some argument that the loss of evidence might take one piece out of context, it's going to become this sweeping rule that can always be used to justify key evidence in a case. It is of course true that this evidence is highly prejudicial for Mr. Overcash. That is certainly true. It is smoking gun evidence that places him in the convenience store at the time that the stolen check was cashed. But of course, smoking gun evidence will always be highly prejudicial, and that is not the test that Rule 106 asks this court to decide. That would be more proper under a different rule of evidence, perhaps. If this testimony comes in, and again, there are three pieces of testimony. There's both the officer's testimony about what he saw in the photograph that Ms. Soriano showed him, and there's the testimony from the two witnesses about what they saw watching the video. If that testimony comes in, Mr. Overcash simply cannot establish prejudice here. If that testimony comes in, there's testimony from three witnesses that he was in the store at the time the check was cashed. There's also the evidence that he was working at the Golden Corral on the day that the check was stolen. There's the evidence from Ms. Heath, the manager of the convenience store, that Mr. Overcash regularly went to that convenience store. And there's the testimony that when Ms. Soriano, his boss, approached him to mention that this check had been lost and that the police would be showing up, that he left the Golden Corral with no explanation and never came back. So all of that evidence cumulatively is certainly enough for a jury to have convicted Mr. Overcash, and the state would submit that Mr. Overcash has utterly failed to prove prejudice if that testimony comes in. Of course, Mr. Osborne has argued that it would be completely unfair for the state to expect Mr. Overcash to explain what might have been in that video. And while perhaps that might be true in some cases, it's hard to argue that's the case here. The theory of the trial counsel below was never that Mr. Overcash was not in the convenience store. At page 234, I believe it is, of the record, in moving to dismiss this case, Mr. Overcash, 243, excuse me, Mr. Overcash's trial counsel conceded that there was evidence that placed Mr. Overcash in the store, but seemed to argue, as Mr. Osborne has perhaps suggested, that maybe Mr. Overcash was doing something other than cashing a check. And if it is true that Mr. Overcash was in the store, as the surveillance video and photograph suggested, then he should be able to tell us why that snapshot is taken out of context. Was he, in fact, passing a lottery ticket? Was he, as his trial counsel suggested during the trial, instead buying soda or a drink or something like that? He doesn't need to see the video itself to explain why a photograph of him in the store at the time of the crime might be misleading to the jury if, in fact, there is an innocent reason that he was there.
But that would require him to testify, right?
No, Your Honor, I don't believe it would, because the way that this is typically handled and was handled here is that the jury is removed from the room, the judge asks what the objection is and for a justification, and his trial counsel could have simply explained, you know, my client was in fact buying soda or a candy bar or cashing a lottery ticket, and if the jury sees just this one snapshot, they are undoubtedly going to believe that he was the one cashing the check, and if they had been able to watch this video, they would have seen he was doing something else. But of course, an explanation of that kind was never put forward, and assuming that Mr. Mr. Overcash was in fact in the store, he should presumably have been able to explain why it was that this video and photograph were so misleading, but no explanation of that kind was ever put forward. I do want to touch briefly on the Yavakpour case because that's been the focus of much of the argument and the briefing. Of course, this is a case from the Eastern District of New York, which is not binding on this court by any means. But it's also a case that seems extremely focused on the fact that the government had destroyed evidence. The court imposes sanctions on the government. The court repeatedly talks about spoliation. It says this was not an inadvertent erasure, and such spoliation, especially in a criminal case where one's very liberty is at stake, is unacceptable. So it is true that Yavakpour is one case where a court does in fact exclude evidence under Rule 106. But what seemed to be driving the court's analysis there was the federal government's culpability in destroying that evidence. Of course, here there's no similar culpability. We know from the trial record that what happened here is Ms. Soriano and Ms. Heath watched the video together. A storm came up. The power was knocked out at the convenience store. By the time the police got there, they were unable to watch the video because the power was still out, and when they came back the next day, the video was no longer there. It's not clear what happened to the video exactly, but there is certainly no suggestion that the state is to blame for the loss of this evidence in the same way that the federal government was clearly to blame for the destruction of evidence in Yavakpour. Lastly, I'll touch briefly on the photograph. As with the testimony, it's not clear at all from the face of Rule 106 that the rule of completeness applies at all to photographs. Of course, this is a photograph of a surveillance video, but it's also not clear that Rule 106 was ever intended to apply sweepingly to videos as opposed to recorded statements. It doesn't use the word recording as Rule 1004, the best evidence rule, uses. It uses recorded statements as opposed to recordings. So it's not at all clear that surveillance videos should fall under the ambit of the rule of completeness in the first place. It's also not at all clear that the rule of completeness can be used in North Carolina courts to exclude evidence. That is, Rule 106 has long been believed to be a rule of inclusion, not a rule of exclusion. And I have not been able to find any case from this court or any other North Carolina court where Rule 106 is used to keep evidence out of court as opposed to forcing the admission of evidence that would put evidence that's being proffered into a broader context. So I think there's a serious threshold question as to whether Rule 106 should apply here at all with respect to this photograph. But again, of course, even if it does, the same problems crop up with the testimony. Mr. Overcash's trial counsel utterly failed to explain why it was that this photograph would have been misleading to the jury, and why having broader context and more of the video would have been helpful in explaining to the jury what had really happened. Of course, as several of Your Honor's questions have implied, Mr. Overcash's trial counsel did have the opportunity to cross-examine these witnesses, and had the video or the photograph been taken out of context, she certainly could have inquired as to why that might have been and asked questions about whether he went up to the counter to do for some other purpose. She did ask questions to that effect. She also asked questions making clear that they had not been able to see with certainty that what was in his hand was a check as opposed to, for instance, a lottery ticket. And that's the kind of thing that is proper in challenging this evidence, challenging through cross-examination exactly how confident the witnesses who saw the video are that what they saw was Mr. Overcash passing a forged check. What is not proper is forcing the state to give up its best evidence simply because, through no fault of their own, the evidence was lost. So again, I want to emphasize how many different paths this court has to affirmance. It could hold, first, that Rule 106 cannot be used to exclude evidence ever, that it's a rule of inclusion that can be used to force the introduction of more evidence, but not to keep evidence out. It could hold that Rule 106 excludes or can force the inclusion of exactly the kind of evidence that it says it does, that is writings and recorded statements, and that Rule 106 does not apply to testimony, and it does not apply to photographs of videos. The court could hold alternatively that, that Rule 106 does apply to this kind of evidence, but that a trial counsel has to do more than simply say at a high level that evidence was taken out of context to carry its burden in proving that Rule 106 should apply. In other words, there needs to be more of an explanation. You can't simply assert this bare minimum of evidence being taken out of context and in so doing exclude evidence. Or as a fourth option, this court could turn to prejudice and hold simply that irrespective of whether it was proper to admit this evidence or not, Mr. Overcash cannot establish prejudice in this case. So again, many different options, all of which the state would submit point towards affirmance in this case. If there are no further questions, I would simply ask the court to affirm.
All right, thank you.
With the few minutes I have available, let me respond to several of the arguments made by the state. Regarding the preservation of objections to the testimony, defense counsel objected to Mr. Overcash's boss, Ms. Heath, on page 184 of the transcript. They objected to Soriano's on page 216 and 217, and they objected to the officer's testimony on page 203. I believe those objections were good enough, sufficient enough under this court's case law to preserve the challenge to the testimony. Obviously, you all will decide whether that's correct or not. The state argues that Rule 106 has never been used by this court to exclude testimony or photographs. And I apologize for not remembering the case's name, but Judge Inman, you wrote a case recently. It was a Fourth Amendment case, and the defendant asked for the inclusion of a post-arrest or post-stop video coming in. So this court has applied Rule 106 to photographs. The video, which, as Judge Trout said, is just a bunch of photographs. I believe that Rule 106 does apply to testimony based on our Supreme Court's decision in Thompson, which says that a defendant or the adverse party is entitled to the admission of the entire statement, right, when you're admitting the completion evidence, the entire statement or anything so closely related that in fairness it should be admitted. Anything so closely related. Right? That, to me, covers testimony as well as photographs or video. The state also argues that Rule 106 doesn't apply to photographs here today, but that's not the state's position in its brief. It conceded in its brief that Rule 106 applied to photographs and surveillance videos or videos. Federal courts across the country have interpreted the exact same language in the federal rule as applying to photographs and video. I cite just several in my brief: Spearman, Brewer, and Williston. There are several state cases that I also cite that interpret state rules 106 that are the exact same as ours, and they have applied them to videos and photographs. The state also argues that this court has never used 106 to exclude evidence. And that's true, but this court also has not adopted the state's per se rule that Rule 106 can never be used to exclude evidence. That's what came up in this court's decision in Hall. The defendant asked for the exclusion of evidence under Rule 106. This court didn't say Rule 106 can't be used to exclude evidence, go away. This court applied the factors used in Yevik-Pour and in Codrington to decide, based on the facts of that case, whether to exclude evidence. The state was asked about laying a foundation for the testimony for the witnesses about what they watched in the videos. They certainly could have been asked questions and were asked questions to lay the foundation. But their testimony should not have gone any further than, did you watch a video? Yes, I did. Right? They should not have been allowed to testify to what the content of the video was. They can be asked all they want about whether they watched a video, but they can't testify about what the video showed. The state also mentioned the best evidence rule. But I think it's important to remember about the best evidence is the evidence has to be admissible first before the best evidence rule applies. Best evidence rule is a rule of preference. Right? Here, the testimony and the photographs should have been excluded. They were inadmissible under Rule 106, so the best evidence rule doesn't apply. Talking about the hypothetical that you gave about the photos of a crime scene, that's not what we have here. The photos aren't photos of a photo at a crime scene. That's what we have here. It's a photo of a photo. It's a photo of a surveillance video. And I think it's also important to remember that the state mentioned that the defendants conceded at the motion to dismiss stage that defense counsel acknowledged that there was evidence that the defendant was in the convenience store. But that was at the motion to dismiss stage. The challenged evidence had already been admitted. So there was evidence in the record. So it's not appropriate to look at that statement then after the evidence had already been admitted. And my last point is the state isn't faced with or forced to exclude its best evidence in this case. The state just had to call Ms. Dixon, just like the prosecution did in Yevik-Pour and Codrington. She could have given the context that they needed. The state made the strategic decision to not call an impeachable witness and to admit an unimpeachable set of photographs. That was unfair to Mr. Overcash. That's all I have. Thank you.
Thank you very much for your arguments. And we will adjourn.
All rise. This session of the North Carolina Court of Appeals is adjourned.
Thanks, you too. It's a fun case.
Say that again? Thank you. Yes.
Dean. How are you?